Welcome back to this final part of co-ownership, severance in land law. In the last segment, we started off looking at the ways that you sever in respect of the joint tenancy being converted into a tenancy in common. And we looked at section 36.2 and the notice, and we also considered some ways in respect of Williams and Ensman. Now then, the other way in Williams and Ensman that severance can be effected is by mutual agreement, and it must be mutual agreement between all the joint tenants. So all the joint tenants must agree, not just some of them, that one or more of their number will hold as a tenant in common from then on. Now this doesn't have to be in writing. The mutual agreement serves the purpose of showing that there is an intention to sever. Now, the point, of course, is, again, do look at an exam question to see if, as I raised in the last segment, is it a situation where the examiner says to you, A and B have already severed, so in equity, all we have is C and D as joint tenants. Because, again, by analogy, there may be a situation for you to discuss that the mutual agreement serves the purpose of showing an intention to sever. Now, intention to sever, of course, was somewhat made clear in the case of Burgess and Rawnsley, a 1975 case. The facts are that in 1966, there was a scripture rally in Trafalgar Square. Now, a widower, Mr. Honeck, attended the rally. Mr. Honeck was about 63 years old. Now there was a widow, Mrs. Rawnsley, who's the defendant. She was also at the scripture rally. She was about 60 years old. He went up to her and introduced himself. She said he was not much to look at. In fact, she said he looked like a tramp. She said he had been picking up fag ends. That's the little ends of cigarettes. And they got on well enough, it appears, to have exchanged addresses. So even though he looked like a tramp and was picking up stuff off the floor, they nevertheless got together. They bought a house, which was conveyed to them as beneficial joint tenants. Mr. Honeck, of course, died, and the plaintiff in this case was his daughter. She was claiming that the equitable joint tenancy had been severed so that his half share passed to her on Mr. Honeck's death. Well, what had happened? The point was that Mrs. Burgess had agreed orally to sell her share in the house to Mr. Honeck. They had not agreed as such to sever the joint tenancy, but it was necessarily implied in the agreement that the parties had. Because the point to be made from the case is that you cannot agree to something unless you thought that a state of affairs existed. So you cannot agree to buy and sell a share in a property unless you thought yourself that you had a separate share to buy and sell. And that was the point here. Because one of the things to take on board with Burgess and Rawnsley is that this was an oral agreement between the parties. But the point is that what we're looking at here was that the intention was present. So this is not of the similar type of cases where you would argue in an exam, for example, that, well, this is an oral agreement and so it has no place in land law. That is not the point. The agreement to sell was not enforceable because it was oral. But there was, within that oral agreement, an agreement to sever. And the point is that that does not have to be in writing. So upon severance, we're seeing that there is, of course, an undivided share which would have been in effect inter vivos, i.e. before Mr. Honeck died. So the courts considered that severance had been effected based on the fact that there was mutual agreement between the parties. The other way, of course, is that there is mutual conduct in respect of the ways the parties have conducted themselves. we can still use the case of Burgess and Rawnsley in order to show this. Because again, remember that I flagged up that you would not be agreeing to sell something if you didn't think you had an agreement, if you didn't think you had a share to agree to sell. So the point is, if you are conducting yourself as one of the joint tenants as if you have a share, and the other party is similarly conducting him or herself as if they have a share, then that may amount to the mutual conduct that Williams and Edmonds says will operate to effect severance. The question then is, of course, what amounts to conduct? The fact is, there's no hard and fast rule. It is a matter of fact and degree. And again, I said to you, look at, for example, Burgess and Rawnsley. The court says it depends on the circumstances. So if you see some kind of long-term conduct or behavior being exhibited where the joint tenants have behaved for a long time as though they were tenants in common, each with his own individual share, then that may amount to a tenancy in common. It's interesting that in a case, Barton and Morris in 1985, the proceeds from a business which was in separate names was done apparently for a business reason, and the court did not consider that this was sufficient conduct amounting to severance. Now, one other way, of course, of severing is mutual wills, where A leaves all his property to B in his will for B's use during B's lifetime, after which it passes to C. B equally leaves all his property to A in her will for A's use during his lifetime, after which it passes to C. The idea of mutual wills is that two persons, for example, it is used, for example, in situations where you have husband and wife. They have a joint tenancy at law, but the parties believe that they have a share. So they make a mutual will. And the mutual will says, husband will leave all property to wife. On wife's death, it goes to the children. Wife draws an exact will that says, property left to husband. If husband dies, it goes to the children. Now, the problem, of course, is that let's assume wife dies. But then husband marries a nicer, prettier, younger model and decides that he's not going to let the children have anything. Well, the courts will consider that the conduct of the parties as such, in respect of the mutual wills, amounts to a situation where, based on the mutual wills, there has been severance. Now, there are various types of advances in respect of the basis that mutual wills amount to severance. And it could be that it sits on conduct, the parties dealing with the property as if they have individual shares. It could also be by mutual agreement. But certainly, mutual wills is one way that severance can be effected. Now, the last point, of course, is that homicide will operate to effect severance. And there is a rule of policy that if one person commits a serious crime, deliberately and intentionally against another, resulting in the other co-owner's death, then the killer cannot benefit from the death. This rule is founded in the principle of public policy that no one should benefit from his or her own crime. So if A and B are beneficial joint tenants and A murders B, A will then hold the legal estate on trust for himself and B's estate as tenants in common in equal shares. There is a rule of public policy that, of course, if one person commits a serious offense, this is what will happen. Now, under the forfeiture rules, you would have to forfeit any gain you have made from the crime, and that, of course, is the basis for that principle. The last section that we will consider in this area is this. Whenever you're looking at any type of trust situation, so whether you sever or whether you're looking at a situation where you're holding on trust, then the Trust of Land and Appointment of Trustees Act 1996 becomes very relevant. Whenever you're discussing, for example, a severance question, I would urge you that after each event that has occurred to a co-owner, you let the examiner know at that point what the current situation is. So let's say, for example, the examiner says to you, A, B, C, and D own property. A then mortgages his portion to the ABC bank. You should explain to the examiner or discuss in the answer the idea of alienation, but at the end of that paragraph, you ought to at least also say that at this juncture, A, B, C, and D, as legal joint tenants, now hold on trust for ABC Bank, 25% TIC, and B, C, and D, 75% joint tenants, because it also helps you to logically follow the discussion. The further discussion, of course, is in the aspect or in the area of considering what happens when, for example, various events have been set out. So one person alienates, one person dies, there's a mutual agreement issue, and we get to the end of the question that says the bank wants the property sold and B, C, and D wants to remain in the property. Well, the Trust of Land and Appointment of Trustees Act is very important in that context. Now, there are various sections which I will flag up. For example, Section 1 sets out definitions and it tells you what kind of trusts are included. Section 2 tells you that strict settlements can no longer be created, for example, when you look at successive interest in land. Section 4 says there's no longer a duty to sell the land in a trust for land. And Section 5 says a trust for sale implied by statute is now a trust of land, because the Trust of Land and Appointment Trustees Act is saying everything that operated prior to 1996, this distinction between strict settlement and trust for sale, and depending on whether the property is held for investment or if it is a property where you're looking at the home, for example, it doesn't operate after 1995. The point being, everything now becomes a trust of land. And of course, the discussion you should focus on and the sections which are important are sections 12, 13, and extremely important, section 14 and section 15. Section 12 says that all beneficiaries have a right to occupy the land. And it gives the beneficiaries a right to occupy the land and live there. Of course, it must be somebody who is beneficially entitled, as explained in Section 9, for example. Section 13 says where two or more beneficiaries are entitled to occupy, then the trustees may exclude or restrict the entitlement of any one of them or more of them. But when the court is deciding who can occupy, the fact is the trustee must act reasonably, and reasonably is defined objectively. Section 14 is extremely important because where there's a dispute, for example, ABC Bank wants to sell and the other parties want to remain in the property, then given the dispute, any party, whether the bank or one of the other co-owners, may make an application under Section 14 to the court, asking the court to resolve the dispute. And the court will resolve the dispute by having regard to the factors set out in Section 15. Now, the factors set out in Section 15 are whether or not the intention of the parties who created the trust can still be considered. So they look at what was the intention when the persons created the trust, what was the purpose for which the property subject to the trust was held. It will also look at the welfare of any minor who occupies the property or who might reasonably be expected to occupy the property. And also it will look at, for example, if there are the types of secured creditors. Now, just by way of flagging up, please bear in mind that if the examiner tells you that, for example, the person in the property is pregnant, or the person who wants to stay in the property is pregnant, this may fall under a minor who may reasonably be expected to occupy the property. Now, to conclude, the previous case law is very relevant when you're considering the Section 15 factors. And certain cases like for example, Reed Buchanan Wollaston's conveyance as to whether an order for sale will be made where there was a trust for sale, the court said no, as the purpose of the trust can still be fulfilled. So if it was that the property was bought for a holiday home and 3 of the people are still there within the trust scenario who can use it as a holiday home, then arguably the purpose may still be able to be fulfilled. Case also is Re Evers Trust, as a previous case when you're looking at the factors, and I would urge you to take these on board. In a nutshell then, that is what we're looking at when we consider the whole context of co-ownership relative to severance. We will, of course, in a later lecture, consider co-ownership, and in particular, looking at the trust, and specifically as it relates to the matrimonial home and the recent cases which have come on board.